Good morning, class. So today we are going to start with Specific Relief Act 1877. All right. So in our previous class, if you remember, we have completed and we have done with contract. What is contract and what is the concept of a contract? All right. So let us have a quick revision before we start this because it is interrelated. All right. So what is a contract? A contract is formed between two parties, isn't it? Or more than two parties. It is an agreement which can be in oral or in written, isn't it? And there has to be acceptance and there has to be proposal in order to have a contract, and there has to be a consideration in order to have a full contract. Now we all know what is proposal, what is acceptance, isn't it? And we also know what is consideration. Now, in order to have a full contract, there must be another one important thing or ingredient, that is capacity to contract. Now, who can enter into a contract? So, according to the Indian Contract Act, there are a few things which there has to be fulfilled in order to have a contract. That is, a person who is entering into a contract must be of a sound mind. He must be a normal human being. If a person is of unsound mind, in a local language, pogla or a crack, all right, so that person or that contract is not valid. It will be a void contract. So we all know the concept of contract. All right. Now we also have learned law of torts when we were in class in our previous session. What is law of torts, isn't it? Now these are the things which are used in our day-to-day daily lives, isn't it? So why Specific Relief Act 1877 was introduced? Now, we must always remember, in a contract, wherever there is a damage, if the contract is broken, then the compensation, the remedy is paying compensation through money, isn't it? If Mr. A and B enters into a contract, all right, and Mr. A says, if Mr. A violates the terms and the condition of a contract, then it will be a void contract. The contract is broken. Now, how Mr. B will gain? Mr. B will gain by some monetary, like Mr. B will claim for some compensation in the form of monetary. All right. Now, in some cases in contract, monetary compensation is only not enough, and that is the reason why the Specific Relief Act of 1877 was introduced. So let us try to read the first introduction part. In order to provide relief in cases relating to contracts, torts and other cases, specific relief was enacted. So as I've already said, in order to provide some relief to whom? To those who have been exploited or who have broken contracts. To provide reliefs in cases relating to contracts, torts and other cases, specific relief was enacted. This legislation had come necessary because the Indian Contract Act of 1872 provided only relief of compensation in case of breach of contract. So why Specific Relief Act was introduced? Because Indian Contract Act of 1872 only had compensation, all right, compensation to the party who had entered into a contract. So this was the reason why this Specific Relief Act was introduced. It was found that there might be a situation where the grant of compensation would not afford adequate relief, and only specific performance of the contract would render justice and provide adequate relief. So sometimes what happens is only paying compensation is not enough. The damage done because of a void contract or a broken contract, sometimes the damage is much more, scale. So in order to fulfill that thing, this Specific Relief Act of 1877 was introduced. So there are 3 or 4 types of remedies for this Specific Relief Act of 1877. All right. So kinds of remedies granted by a court under the provision of the Specific Relief Act. These are, number 1, recovery of possession of property. So number 1 point is recovery of possession of property. Alright, so this is the first remedy which the court has provided. Now what is recovery of possession of the property? A person enjoying ownership rights to a particular immovable property is entitled to possession of that property. Now, if I own a house, alright, and a plot of land. Now, this is my house and this plot of land belongs to me, so automatically I am the owner. Isn't it? I am the owner of this property. Isn't it? Now, possession is very important and significant ingredient of ownership right. So, this is my property, alright, and I'm staying over here. Isn't it? So, I have a possession. Isn't it? My boundaries are demarcated and I have a house inside that property and I am staying over there. I have a possession. So, possession in ownership is a very important ingredient in Ownership Act. Alright? So, as speculated in section 52 clause 1 clause F of the Transfer of Property Act, seller is bound to give possession of the property to buyer of the same. Now, if I decide to sell this property to Mr. B, alright, Mr. B is interested in buying my property and I am also interested in selling my property. I've made an offer. Now remember what we have learned in contract. I've made an offer. The offer is, let's say, 50 lakhs. Alright, 50 lakhs. I have said that, okay, I'm ready to sell my property at 50 lakhs. I have made an offer and Mr. B has accepted my offer. Mr. B has accepted my offer. He is ready to pay me 50 lakhs. Now, there has been a contract between me and Mr. B, isn't it? Because I have already said that, okay, I'm willing to buy this property and Mr. B has already said that, okay, he will buy this property at the sum of 50 lakhs. So, the first step of contract has been there. Now, there is a consideration, another ingredient in contract. The consideration is that Mr. B is getting my property and I'm getting this 50 lakhs. Consideration is also there. So this is a valid contract. Now, after selling this house, I don't leave this place. I have already sold this house. Mr. B has already given me the sum of money which I had claimed, even though alright, so I am not ready to leave my position of this from this property. So where will Mr. B go now? There has to be some remedy, isn't it? There has to be some way in order to acquire this property, because now he has already paid me this. Now what will Mr. B do? He will go through recovery of possession of property. So he has to recover the possession from my to him. Okay, so the recovery of possession of property is all about this. Alright, so this is one remedies granted by the court under the provision of Specific Relief Act. Now, another one is, the second one is, alright, so when legal owner of a property is inappropriately disposed of his property, he or she has every right to recover possession of the said property in a lawfully manner. As I have already said, that if I have sold my property, now I have to leave that place, and if I don't leave that place, how that Mr. B will come and stay, isn't it? So if I don't, then recovery of possession of property can be applied, alright, under Specific Relief Act. Now, when can a person file a case for recovery of possession of property? Disposition of the person was without his consent, alright. So I am staying over my property even though I have sold. Now Mr. B is not being able to dispose me out of my property, previous property. Now there has to be a disposition of ownership or a person, alright. Another one is, suit must be entitled within 6 months. So in this case, Mr. B must file a civil suit within 6 months of time. All right. So disposition is not by the government or under any government orders. All right. So, but if sometimes, if this plot of land belongs to Mr. A, he has a very huge plot of land, and the government takes away his part of land through acquisition. It is called a process called acquisition. Now, if the government has taken this plot of land and Mr. B is not willing to give this thing, then the government can recover of possession of property, go through this recovery of possession of property. All right. So this is what B, the last point, is trying to tell us. Now, another remedy is specific performance of contract. All right. So what is specific performance of contract? Specific performance is a specialized remedy used by courts where no other remedy such as money will be adequately compensate the other party. Now, this is a special type of remedy which is mostly used by the courts. All right, mostly used by the courts. Number 2 is specific performance of contract. So this is the number 2 point, specific performance of contract. Specific performance is a specialized remedy used by courts where no other remedy such as money will be adequately compensate the other parties. So sometimes there might be a case where money is not everything, where money is not only a way of compensation. So what will the court do? The court will apply specific performance of contract. All right. If a legal remedy will put the injured party in the position he or she would have enjoyed had the contract been fully performed, then the court will use the option instead. The common reason courts grant specific performance is that the subject of the court contract is unique, when it is not a matter of money or where the true amount of damage is unclear. When a contract is for the sale of a unique property, for instance, mere money damages may not remedy the purchaser's situation. So, in contract, normally what happens is when two persons enters into a contract, all right, A or C or A or B, when two persons enter into a contract, and if one of the party betrays and breaks the contract, what will be the compensation? The court tries to deal with money, through money, isn't it? But in some cases, there are unique property or a special type of contracts where money is not only enough. For example, what is unique property now? A unique property can be classified as a property or a house. So, if Mr. A and Mr. C, they have entered into a contract and Mr. A has already said that, okay, I am willing to sell this property to Mr. C, and they have entered into a contract. There has been all documents signed, all right, entering into a contract saying that A and C are entering into a contract and C is going to buy from Mr. A. Now, in course of time, Mr. A again decides that, no, I am not ready to buy this property. I'm not ready to sell this property. Now what will happen? That contract has been broken, that contract has been damaged. So over here, the court says that in this type of cases, monetary compensation is not enough, but there has to be some specific performance of contract. So the court will order Mr. A that you have to sell this property because you have already entered into a contract. So this is what it is trying to tell us. All right. Now the last one is recession of contract. All right. So what is recession of contract? Contract rescission refers to the termination or cancellation of a contract. It is sometimes called cancellation or revoke. All right. So rescission of contract. The third point over here is rescission of contract. What is rescission of contract? It is a termination or a cancellation. In a very simple language, it is a cancellation or a termination of a contract. The word rescission comes from the word resigned, which means to cancel. All right. The purpose of contract rescission is to restore the parties to the original status before the contract was made. Rescission is often available as a remedy in case where there are issues with the way that the contract was formed. Now, as you remember that in order to be a fully formed contract or a legal contract, there are certain criteria. As I have already said that the person must not be minor, that person must be of unsound mind. Now, again, there is a property, all right, and there are two people, Mr. A and Mr. B, and there was a contract that Mr. A will sell his property to Mr. B. But later on, if Mr. A is happen to be of unsound mind, all right, he has some mental problem, then the court can use this remedy as rescission of contract. So the contract which was formed between A and B will be cancelled or revoked. Why? Because Mr. A, who had entered into a contract, is of unsound mind, or Mr. A may be of below 18 years old. He is a minor. All right. So due to that, rescission of contract can be used in this type of cases. Contracts can be resigned under following circumstances. Number one, consent. Both parties must manifest their intent to have the contract reclined. It is best if they indicate their consent through additional written document. So, number one is consent. The ways where the contract can be cancelled, the number one point is consent. Now, if A and B both agrees that okay, they are not, although they had entered into a contract, but later on Mr. A and Mr. B decides, okay, I'm not ready to sell and I'm not ready to buy. It is the consent of both Mr. A and Mr. B. So in these kind of cases, contract can be cancelled. Number two is issue with contract formation. The contract must be made under legal condition and consent cannot be acquired by force or fraud. So before entering into a contract, it has to be in a legal way. It has to be in a legal way. If a person enters into a contract by a fraud means, then that contract can be cancelled. The third one is fraud. If both the parties have entered into a contract in a fraud manner, then it can be cancelled. All right. And the next one is what instruments can be cancelled. So written instruments, registered instruments, undersigned instrument, void instrument, voidable instrument, unconstitutional instrument. These are the instruments that can be cancelled. We all know what is written. It is in a written form, document one, registered, that we go to the court or to the land reform office and we register that thing. All right. So unregistered, if the property is unregistered, void bhaneko, if it's illegal or a fraud manner, voidable, and unconstitutional if the property is unconstitutional. So these are the things. All right. Now the sixth one is important, that is called injunction. What is an injunction? An injunction is a judicial process whereby a party is required to refrain from doing any particular act. It is remedy in the form of an order of the court addressed to a particular person that either prohibits him from doing or continue to do particular act, prohibiting injunction, or orders him to carry out a certain act, mandatory injunction. So what is an injunction? Injunction is a judicial process. Injunction is nothing but it is a judicial process where the courts order a party to stop doing anything apart. All right. So if there is a case going on regarding a property, all right, if there is a case going on regarding a property and there are two parties, all right, now if one of the party is able to file an injunction and if the court thinks that yes, by doing so another party will not be hampered, then the court may give injunction. And if the court gives injunction, then both the parties are not allowed to do any activities in their claimed property. All right, this is all about Specific Relief Act. And if you don't understand anything, if you have any problem, then you can always call me or WhatsApp me. All right, so thank you.